Welcome to Legalized Negligence. We are Sabrina, Philip, and I am Travis. We are not lawyers, so do your own research. We will be speaking about what sovereign immunity is, how it applies to hospitals, and the state's application of caps as they apply to themselves. We will be playing a video on House Bill 569, Suits Against the Government, and we would like you to consider what our representatives have to say about the caps and then associate what they say with Florida statute 768.21 subsection 8.
And I guess this would be a good time for me to share the screen.
Yep.
Okay. It'll pop up there in just a minute. All right, here we go.
Thank you. Great job. Very efficient. Next up, PCS for House Bill 569 by Representative McFarland, Suits Against the Government. Representative McFarland, you're recognized to explain your bill.
Thank you, Mr. Chair. And it must be Thursday afternoon after lasagna for lunch. But we're going to wake up here, folks. The concept of sovereign immunity comes from the English king being shielded against accountability to his filthy commoner subjects. The king can do no wrong. And it is in the American character to be highly skeptical of sovereigns, but we're also very skeptical of taxes. So although we've retained some portion of sovereign immunity, we've made it, so our sovereigns are not immune from us. We've made it difficult to sue the sovereign in cases of negligence. PCS for House Bill 569 increases the sovereign immunity caps for damages against state and local government entities to $400,000 per individual and $600,000 per incident. It calls for an annual CPI adjustment and reduces the statute of limitations from 4 to 2 years. It increases the statute of limitations, however, for cases of sexual battery against a minor under the age of 16, up to 15 years after the age that they reach, after they turn 18. It allows a local government to settle a claim and pay the settled amount without the need for a claim bill. And it prohibits an insurance policy from requiring a claim bill before payout. It abolishes the common law doctrine of home venue privilege in relation to suits against the state. And I'll point out that this bill has an October 1st, 2024 effective date, as opposed to our normal July 1st effective date. And that's to match with the typical fiscal year of local governments. That, Mr. Chair, is the bill.
Let me explain the bill. Any questions? Any questions for Representative McFarland? Representative Coster, you're recognized.
Thank you, Chair, and thank you, Rep, for the bill. Definitely in support. I have a question on the statute of limitations issue. I know we're moving it from 4 years to 2 years. I'm okay with that. But my understanding is with sovereign immunity claims, there's a pre-suit notice requirement, which then sort of eats into maybe about 6 months of the statute of limitations. So I'm wondering, I know in med-mal lawsuits that also have a similar pre-suit notice requirement, we told the statute of limitations. Is that something, does this bill do that?
Representative McFarland, you're recognized.
Thank you, Mr. Chair, and thank you, Representative Coster. You're right, the bill, so I mentioned at the start that the bill reduces the statute of limitations from 4 years to 2 years. That's to align us with our tort reform package that we did last year and try to make suits against a sovereign as equal to suits against a private citizen as possible. So we're going to match that there. I do understand this. It's unique when you sue a government. There's a 6-month waiting period there, and I see how that creates a disparity between a private suit and a suit against a sovereign. The good thing about the committee process, we're at the stage of session where we notice a bill and everyone, flurries to read it because there's so many bills that have been filed and we have good ideas that come forward. And I think this is just such one of them. And that's an area that I'm looking forward to working on as the bill moves forward.
We had a very similar argument with regard to the pre-suit requirements for med-mal claim, is that it eats into your statute of limitations. And it sounds like she brought up the exact same thing. Did y'all get that they're going to adjust the language?
Yeah, it creates a tolling.
Yeah, so they're going to make it where it does not take 6 months out of your 2 years. Is that correct?
That is my understanding, that they will attempt to make a modification. Whether or not it goes through,
I'm going to take just 1 second and put a screen up here. Does that show Magna Carta?
Yes.
Okay. This is a very good explanation of sovereign immunity. And y'all hear me complain all the time about people not understanding the foundation of our government. Magna Carta dates back to the year 1215, and going back even further than that into, I think it was 1060 or so, I believe. Things started growing in England, and the kings had become very oppressive towards the people, and the people were getting angrier and angrier all the time. And in the year 1215, they literally put a blade against the King John, if I remember right, against his throat, and made him sign this Magna Carta, which Magna Carta stands for the Great Charter. People who want to learn about this and learn the history of it, you can see the web address at the top is Britannica.com, and just look up the topic of Magna Carta and you can get this website and learn all about it. A lot of people don't stop to think these days that our Constitution in America was written in 1787. It was ratified in 1789, and then in 1791 the Bill of Rights was added to it. But how did we get to that? What led up to that? And our Constitution actually has it's easily 1,000-year genealogy. That what happened over the previous 1,000 years that led up to our founders creating our form of government in 1787. And you can actually take it further back than that, but this is a real good explanation. You can just Google Magna Carta and look for the site that is Britannica.com, and you can learn an awful lot about it.
Is that what's referred to as our common law?
Well, no, they talk about common law in the Magna Carta. But Magna Carta was basically the people standing up against the king and saying, you are not going to do this stuff to us anymore. And there were a couple of documents before that, but you go from Magna Carta to the English Bill of Rights, and you just see this. There's actually 5 documents in total that led up to our Constitution. You say, well, how is that possible? Because that was in England. Well, not a single American fought the American Revolution. We weren't America until after that war was won. It was a bunch of British colonists who fought the American Revolution in order to create America. So they were going by English law. They were standing up as Englishmen to say, King, we're not going to allow you to oppress us any further. And the end result of that was America. And when we began to write our new form of government, all we had to draw from was what we knew as Englishmen. And then we started making changes in the way that the British government operated and the way that we wanted America to operate. And the idea of sovereign immunity comes from Magna Carta, where the people were telling the king, you're not going to do this to us anymore. But it's good to know the history of all of that if you want to be able to speak intelligently about what goes on today. So I'll get back to the video.
Further questions? Being none, we'll move into public testimony. Jess M. McCarthy of the Miami-Dade County Attorney's Office waives in opposition. Thank you, sir. Marty Cassini, Broward County, waives in opposition. Bob McKee, Florida Association of Counties, waives in opposition. David Cruz, Florida League of Cities. Mr. Cruz, you're recognized.
Thank you, Mr. Chairman and committee members. My name is David Cruz of the Florida League of Cities, and I am in the unenviable position of being up here in opposition to the sponsor's bill. I have a tremendous amount of respect to the sponsor, and I'm very thankful to the time that she allocated to discuss the bill prior to this committee. I am hopeful that we could work on addressing some of our concerns as the bill moves through the process. I briefly, though, wanted to outline some of those concerns. When we're talking about caps, our members strongly feel that caps are important in Florida. They're an incredibly necessary function to help our taxpayers keep costs down. However, we recognize that this is a policy decision that the Florida legislature gets to make. And so having this discussion in this committee room is an appropriate function, and we are committed to work on that discussion as the bill moves through the process. However, just keep in mind when we're talking about caps that Florida's governments, especially our cities, provide several essential services. Things like fire, police, water, sewer, roads, all of those are essential to our Floridians. And unlike the private sector, we can't adjust our delivery of those services to limit liability. We can't change our business model. We can't have a firefighter ask you to sign a waiver to limit liability before they run into a burning building. And so just keep that in mind as we work on this issue. And at the end of the day is, look, we have over 100 cities in Florida who have a budget of less than $5 million. You could see how large claims could literally bankrupt those cities. And so caps are absolutely necessary. What those caps should be set at is a conversation we're willing to engage at and continue to have that conversation as it moves forward. Let me just briefly touch on two provisions in the bill that I really want to work on as the bill moves. And one of those is dealing with CPI or tying the caps to CPI. Like I mentioned previously, having this discussion in this committee room right now is completely appropriate. Having caps automatically go up is something that gives our members a lot of concerns. We feel that that is a legislative function that all of you should be making, that we should be making in this room and publicly vetting that conversation. And so we would love to see that CPI provision removed from the bill and for the Florida legislature to set caps for sovereign immunity in Florida. I tried to look at other states. I had a really hard time finding others that do it this way with CPI. I only found Colorado, and even they do it every 4 years. I would suggest that's not a model we should follow, and it makes it extremely administratively difficult for us to implement the CPI given our insurance policies run from October 1 to September 30th, but yet the CPI would be coming out on July 1st in the middle of the insurance policy. The second thing I wanted to point out is the bill ties these new caps to the date of final judgment. And that is extremely concerning for us. And let me explain why. If you were to go to City Hall today and you were to slip and fall, caps today in Florida are set at $200,000 for that individual slip and fall accident. However, if you filed a claim and you litigated that claim, it might be 2 to 3 years before you get to a jury verdict. The bill would say that the claims that are in place 3 years later, after you slipped and fell, would be the ones that controlled. Our insurance policy wouldn't cover the increased amount that the claims, that the caps had changed. And so we really think that the caps should be set to the date the accident happened. The date when you slipped and fell should be the caps that are in place for that claim. And so just as you move forward, look, I realize this is the first off, it's the first week of session. The committee process is going to work, and we're going to keep our commitment to the sponsor of the bill to work on these issues. But just don't lose sight of the fact that at the end of the day, we're dealing with taxpayer dollars. It's just incredibly important that our cities, like many of you, want to keep our taxes low. And so we would ask that you enact policies that help us keep our taxes low for our Floridians in our cities. Thank you, Mr. Chair.
Thank you, Mr.
No, let me comment on that. I'm sorry. What he's saying here is that the taxpayers, are having to fund the government, and that if the government causes an injury, that he wants it, and whoever he represents wants it to be where the taxpayer cannot recover because of that injury. My argument would be it cannot be presumed that when the people voted for their legislators to write law that they expected their legislators to prevent them from being able to recover damages if their government harms them. I mean, I wouldn't expect that if I'm voting for somebody to be a representative or a senator, that I'm going to allow them to say, well, I wrote a law that if government harms you in some way, you can't recover any damages. Now, I know that right now they're talking about bringing it up to, what is it, $600,000. But they're arguing against it. You know, they don't want the caps to go up to $600,000. So, you know, he's couching it in terms of a police officer and a fireman and a slip and fall at your county courthouse. I think that's disingenuous for him to do that. I mean, naturally, when people want to make an argument, they're going to pick whatever argument works in their favor. And, you know, if you slip and fall at a county courthouse because somebody didn't put up a floor is wet sign when they mop the floor, I don't think anybody's going to be asking for millions of dollars for that. And I don't think any jury would award $1 million of dollars for that. But if a police officer did something to you, like we saw them do to George Floyd, or we've seen them do to numerous people in the past by violating their rights and, you know, completely either altering their life forever or killing them, absolutely, the people have a right to have government pay them for those injuries. That's my
It
take.
amazes me that he speaks not of taking care of the people that they injure, that it's like there's no responsibility. It's all about self-protection.
Yeah, and that's been my, when I said that this, when Sabrina sent us this video this morning to watch, you know, that's why I thought it applied so perfectly to subsection 8. It's like they don't want to talk about the doctor's negligence. Nobody wants to deal with that. And here, this guy doesn't want them to deal with if the government was negligent. It's like, well, sorry, you know. And somebody else later on in this brings up a very good point about that. And I won't get into it until they do. But I just wanted to kind of set the record straight for people watching this video. Basically, he's saying that your government should be able to negligently injure you and you not be able to do anything about it. And I argue, I don't think that's how the people want to be governed. You know, and it's up to the people to choose how they want to be governed. And when they cast their vote for these senate or for these representatives, you know, I don't think that you can assume that they expected their representatives to treat them in that manner. Did you have something you wanted to say, Sabrina?
No, not too much at this point. I think should listen a little more.
Okay, I just didn't want to ignore you there. I'll go ahead and start it back again.
Great. Bob Harris, Panhandle Area Education Consortium.
Thank you, Mr. Chairman. Members, again, my name is Bob Harris, and I have the honor and privilege of representing the Panhandle Area Educational Consortium. For those of you that don't know, the consortium is statutorily created, and it's all the small and rural school districts that are west of here, all the way to Walton County, Madison, Taylor County, those kinds of places. I serve as both the general counsel for the consortium as well as the attorney. And the reason I say this is because when they get sued, I'm the one who gets that phone call. Some cases like this come up. I have probably 35 or 40, unfortunately, sitting on my desk. We're opposed to this bill, but I want to explain why. And I very much appreciate David Cruz's points. I'm not going to repeat those points. He made some very good points about the CPI and some other things. So I won't repeat those, but let me tell you why. We can't afford this. We just cannot afford this. Insurance cost is one of the biggest costs we have as a small school districts, and all of our districts are very small. For example, Liberty County, if you raise taxes by $1 million, it brings in a whopping $375,000 new dollars. That's how much. Dade County is in the millions, but we can't afford this. So when you talk about increasing the caps, doubling those caps, our insurance rates are going to go up. In all of our school districts, we have a self-insurance fund. Every dollar that we pay out on claims is $1 out of our taxpayers, dollar for dollar. And so we can't afford, if you double the caps, our insurance rates are going to go through the roof, and small school districts, we just can't do that.
Is that sounding familiar to anybody?
Dollar for dollar.
Yeah, I mean, it's like we can't afford it. So what we want you to do is just understand that if government somehow harms your life, then you can't get any kind of restitution from them. Basically, that's what he's saying. We want you to accept that kind of mindset. That's how the government should operate. It can do anything it wants to you, and you can't do anything about it. The same way that they're handling the issue of medical malpractice. We want you to accept that because doctors will leave the state if subsection 8 stays in place and their premiums go up. We want you to accept that you just have to take one for the team. You know, you can't sue if a doctor's negligent. And I think it's great that they're making the same argument for other areas for us to see that it's not just medical malpractice. They're trying to do this across the board and get it to where people can't sue for anything. You just have to accept the fact that your government is your king, which brings us back to Magna Carta, where people said, no, you're not going to do that to us. Sorry.
And as David said, the way the bill's written, it's going to go up by CPI every year. So it's going to increase every year. There's another way to do that. I'll offer that alternative in just a second. There will be more claims. We call it the pot of gold at the end of the rainbow syndrome. If you increase the amount available, there will be more claims. We know that. We talk to other lawyers who ask us, when will this ever be increased? We're ready to file more claims. We know that will happen. And we just can't afford that either. Some people have said, in response to this, that public entities like school districts should be treated just like common tortfeasors. We are not Walmart. We are not Amazon, and we never will be. And let me tell you why. This legislature requires us to provide services to people in our communities, school buses, thousands of miles every day. We have to have PE classes. We have to have field trips. We invite people to our ball games, to our football fields and our basketball courts. We cannot close them. And I have cases sitting on my desk right now today where people have sued us because of something that happened in our basketball courts, on our football fields, during field trips, and our school buses. And so unlike Walmart and Amazon or other companies, we have to do these things. We have to open our doors. And so we need to be treated differently, not just like any other tortfeasor. Please keep that in mind. It's very important.
We need to be treated different. Your pre-suit requirements, just like with medical malpractice pre-suit requirements, deal with any kind of frivolous suit that comes along. If somebody gets hurt playing a game of basketball or whatever on his basketball court, then the pre-suit requirements that they have to deal with cause the two sides to come together and discuss it and figure out, was this just an accident? Or was this the government was negligent? In other words, they knew that there were some boards on the floor of the basketball court that needed to be attended to, and nobody took care of them, and a kid tripped and fell. This is the same argument that they're doing with medical malpractice.
He's talking about the medical board and I'm not medical board, but education board and related activities. Wasn't the Florida lottery supposed to take care of this? Because I see billions in the lottery, periodically. Is that not enough money to cover a year's worth of insurance?
Well, I live in Tennessee, so I don't know exactly about that. We do have a thing in Tennessee where, in case anybody wants to say about, well, you're in Tennessee, what are you talking about Florida law for? I'm the personal representative of my mother's estate. I'm also a citizen of Florida, though I live in Tennessee. And, so I have every right to discuss this. But we have a lottery in Tennessee, and what it's supposed to be used for after the people who run it, get their paychecks, it's supposed to be used to put people get an opportunity to go to college off of a scholarship from the lottery. Money goes to put people through college who couldn't afford it. So I don't know how to answer your question, Travis.
My understanding was, you had the education budget, pre-lottery, And then the lottery was sold to Floridians as it would put a lot of money into education. And what I believe happened, and I was much younger then, is they took away the budget and put education relying upon the lottery. They reallocated the original funds. But, you know, it just seems like there's a lot of money available just from the lottery that a little bit could be funneled to have proper insurance. You know, I don't know the finances of it, but man alive,
Yeah, and
some of these awards.
I'm sure that schools have insurance. They would be required to have insurance, you know, and his argument that if you raise the cap up to 600,000 from what is it now, 300,000, because he said that it's going to double, that there's going to be more lawsuits. No, what's going to happen is the exact same thing that would happen if you take away subsection 8. More attorneys would be willing to take a case because there's some way that they can get paid for their time to take the case, but it still has to go through a pre-suit debate. You know, experts have to look at it and decide, is this a real case or not? And he cannot expect people to say, if negligence on the part of government occurred, that the person should not be able to be compensated for that negligence. Government has to be just as responsible as an individual would have to be. If it is true negligence, then it is something that the government could have dealt with to prevent negligence.
What he's saying with wordplay is that we won't have an increase in the number of cases, you know, of faults. We'll have an increase of attorneys taking on those existing faults.
Yeah.
Because there will be more money available to go after.
Yeah.
He just needs to address the faults.
And that's exactly what we've been saying about medical malpractice. If you address the doctors who are causing the malpractice, the lawsuits go away.
Correct.
It's just that simple.
I think the claims bill process does work. And this is just after being here in the legislature for 40 years and I used to defend claims bills. Let me tell you this. It's just kind of philosophical, I guess. You are the woe button. You all are the woe button for claims. The way the claims bill process works, it says, look, people want money from taxpayers, and we're going to use this process to say at some point in time, we're going to give people money because their claim entitles it. But because you're in charge of the budget, all that money, you're the only one that can put a woe on it to say, no, we've got to look at other things that we're doing and how we're using our resources. You just keep increasing that cap rate every time, put the cost back on us, and kind of get rid of the claims bill process. It's going to be very difficult. And I think you're taking away a great authority and power that you have. The last thing I'll say is this. There is a provision there that says, allows us to settle beyond the insurance amounts that we have. The first thing we get anytime anyone wants to sue our school districts is a letter saying, tell us your insurance policy. We send it to them. But this provision here would allow someone to sue us well beyond those things. I cannot negotiate resolution of claims against our school districts if that language is in there, because they're going to start at millions of dollars. They do already with our insurance policy. You know what our insurance is? They said that's what it'll be. That's what we're settling for, nothing less. If you have this provision there, it's going to go beyond that. We just cannot afford this. And I ask you to reconsider this. We'll work with the sponsor on some of these things. The CPI, for example, I don't think the CPI should be in there. Let's do it every 5 years. Let's come back every 5 years and take a look at it. That's reasonable. Let's take a look at it. Maybe the CPI is going up, it's going down. Let's take a look at it. Let's do that rather than an automatic. Mr. Chairman, members, thank you very much for the opportunity to speak to you.
Thanks, sir.
See, now they want it on their side where every 5 years, let's come back and reevaluate it. But they didn't do that with subsection 8. You know, like Justice Perriente tried to point out, we don't even know if the malpractice crisis continues. You know, that was in 2000. It was 10 years after subsection 8 was passed into law. You know, well, if they want to be able to come back every few years, and we've talked about a sundown clause in the law, if they want to come back and reevaluate, shouldn't we be able to ask them to do the same thing? You know, basically what this guy and those like him want is for us to just accept that government is going to be immune from anything they do that infringes upon your rights or where they were negligent.
And he's kind of wrong in that the cost goes back on him when he said that. It really goes back on the taxpayer.
Yeah, I think he said that with him wearing the cap of the steward of the tax dollars. I think that was the point that he was trying to make when he says it comes back on him. Well, if he's the steward of the tax dollars, I can kind of understand why he would say it like that.
Okay, so is he also the steward of the woe button for causing the injury?
I don't know if he is or isn't, or if somebody else would, I don't know if he's the one that can say the school bus would not have gotten in a wreck if you had replaced the brakes on it when you were supposed to replace the brakes. I don't know if he's the guy who controls that or if it's some other person who controls that. But if a school bus gets in a wreck because the mechanic didn't replace the brakes when they were supposed to be replaced, sorry, the government was negligent. Do you really think that people shouldn't have the ability to recover damages for that? Basically, they don't want the government to be responsible. Just like we've been arguing is that subsection 8 prevents doctors from being accountable for their negligence. Sabrina, this is a great video. I'm glad you found this.
And this is all new to me because I didn't know that, this type of thing even existed. I didn't know that caps on these types of suits existed, so I just found it interesting.
It's funny the rabbit holes you'll start going down when you start researching a topic, isn't it?
Yes, it is.
I've been so focused on subsection 8 that I haven't spent time looking for anything like this. And you explained to me earlier how you came across it, but it is a great example. It's just every time one of them says government, just replace it with doctor, and it's the same arguments that we've been making.
For those watching the video, hang on, because you're going to love what you hear from the representatives when we get there.
Okay.
Matthew Poskay, Florida Justice Association.
And just so people who are kind of new to this know, Florida Justice Association is a group of trial lawyers, and they want the caps to go up because, of course, a trial lawyer is the person you would go to if you want to file a suit against either a doctor or the government. And here, when I say government, it's those hospitals that have sovereign immunity, they're government. But he is somebody, this guy represents the attorneys that we would go to and say, do I have a case?
Mr. Chair, thank you. Representative McFarland, thank you so much for working on this bill. We're thankful for this bill. It helps right wrongs done to citizens. With all due respect, talking about a pot of gold when somebody's been permanently injured makes no sense to me at all. My clients that I represent that I've been doing on the plaintiff side for over 15 years would rather give the money back and have their health back and not be permanently hurt for the rest of their lives. What this bill does is a good compromise. I'd love to have the numbers. We don't have that ability. You all have worked on a good compromise to get fair numbers. As far as the CPI issue, heck, if it had been done every 5 years, we'd be much higher because in the past 50 years, just the cost of medical care has more than doubled. It would be more than double what the caps are here right now. So they haven't changed for 13 years. And then to say, well, don't change it, but if you are going to change it with CPI, do it every 3 or every 5, that doesn't make sense. This is something to help the citizens, your constituents who have been harmed permanently. And this is a fair compromise. And we thank you so much for working with all the stakeholders to reach something that is reasonable in this situation. Thank you.
Thanks, sir. Mark Delagal, Safety Net Hospital Alliance. You're recognized.
Good afternoon, Mr. Chairman, committee members. My name is Mark Delagal, and I'm the General Counsel to the Safety Net Hospital Alliance of Florida. Our members include your legacy teaching hospitals, your public hospitals, your children's hospitals, and your RIPIC hospitals. Our membership consists of 8 facilities or eight systems with many facilities that enjoy sovereign immunity. This would be, you've heard, a cost driver. Let me share with you a result of an actuarial study that our group prepared just to itemize the cost, but I also want to reiterate that it's more than just the cost of the change of numbers that are involved here. We commissioned Willis Towers Watson to look at what the cost of this bill would be on the sovereign entities that I represent, in addition to the state-supported medical schools, the likes of the University of Florida, the University of South Florida, FAU, FSU, et cetera. And this would increase the estimated cost. And this is a very conservative estimate. Be happy to go into more details. Be $107 million a year. Now, that's $107 million a year. That's real money. And what that will have to come out of something that we're already spending money on. And we will reduce service, we will reduce pay, we will reduce whatever it is in order to be able to be able to afford the insurance. And that's a conservative estimate. That is not estimate. Does not consider increased frequency. As was mentioned earlier, when there's a bigger pot of money available, I use this phrase, when the honey pot is bigger, there'll be more bears coming for it. So I know my fraternity brother there, Matthew, probably doesn't like me using that, but that's how I say it. The other thing I want to point out, there's many other things in the bill than the number. The number gets a lot of attention. And I can't argue with the fact that the number's been static for 13 years. And before that, it was static for another 10 years. And before that, it was static for another 10 years. The number is one conversation, but this bill is a wholesale rewrite of the sovereign immunity process. And it has a untold financial cost on all of the sovereigns. So if we were here talking about numbers, I think you'd have a different conversation. But this bill has a number of things that have been pointed out by David and pointed out by Bob that are really going to impact us, and we just don't know how. In life, you know, when you negotiate with anybody about anything, leverage is key. This bill flips the leverage dramatically. And when leverage flips in negotiation, every lawyer on this panel knows what that means. That means the check gets bigger. And that's what's going to happen here. It'll have to play out. And so I would really urge us, if we're going to talk about numbers, that's a fair conversation that I know my folks and other folks that are part of our coalition that includes about 50 sovereign entities that are with us here would love to have and will have with sponsor, but there's a number of provisions that are really problematic. They're nuanced, they're not very sexy, they're not very exciting to discuss. The numbers are easier and more interesting to say, just change the number. So with all that, I want to thank you. I spoke to the sponsor just after she filed the bill, so she knew we were concerned, and we'll keep working with you. Thank you.
Thank you.
Again, he doesn't address the negligence. He doesn't address the injury. All he's concerned about is with the money. And to be fair, he represents the people that this would matter. So he's doing his job as an attorney representing them. You know, I'm not going to knock him for that, but he leaves out the part of the equation that after the dust just settles, you've got an injured person sitting there. You know, and what do you do with their injury? So
Yeah, he doesn't address the untold cost to the injured party.
yeah, he leaves that completely out, and I would expect a good attorney to do that. He wants the other side to bring that up. You know, he's not going to help your case by talking about it. And that's what legalized negligence is trying to do, point this stuff out. You know, I like when a cop comes up to you and starts asking you a bunch of questions. The best thing you can say to him is, I'm not going to help you investigate me. You know, if you think you got something on me, then do your thing, dude. But no, I'm not going to help you further your investigation if I'm going to be the one suffering for it. No
Well,
way.
you ask him what the pay rate is.
Yeah, exactly. I mean, that's why, and you've heard me say, you know, the Constitution is the law that governs those who govern us. And That's why those protections are there. You know, it prevents the government from forcing you to help harm you. You know, the government has certain standards that it has to meet. And that's what the Constitution is all about, whether state or federal. It's telling the government this is how you will function and this is how you will interact with the citizens. It keeps them on a leash.
Well, and that's part of the problem I see with the Supreme Court being a function of the government. You know, I love the separations of powers, but they're still a part of the government and they're like taking care of their own.
Yeah, and unfortunately, that is the corruption of man. You know, it's not designed that way. They are supposed to be an impartial body that acts as a check and balance on the other two branches. In fact, all three branches are supposed to be the same thing. You know, they're a check and balance on the other two branches. But as you will hear them say in a little bit, it takes away that separation of powers. And that's what they're talking about, these claims. You'll hear them mention that a little bit more, is that suddenly the legislature is being put into the position of being the judiciary. And that's unconstitutional to do that. You know, when it's been determined that negligence happened, there's been some kind of award, and the insurance company has to pay that award to the person that was injured. They have to wait years to get it because of these claims, where it has to go before the legislature for the legislature to say yes or no. And now the legislature is acting as the judiciary, which in my view is unconstitutional, in my view.
Thanks, sir. Eric Tinsman, Florida Justice Association. Sir, you're recognized.
Thank you. I'm back. Rep. McFarland, thank you so much for raising these antiquated caps. 200, 300 is just too low. 400, 600. Obviously, we all wish they were higher on our end, but 400, 600 is a fair compromise, a fair number, and thank you. This is going to change people who are seriously injured by the government through no fault of their own. And they're going to be able to get some money. And they didn't want this. They would love to be able to sue a private entity, but the person who injured them was the government, and now they can get up to $400,000 with this bill. So thank you. It's been a long time coming, and it's a fair number. This bill also streamlines the claims bill process. That will lead to less litigation, because right now, even if the local municipality wants to pay the verdict, they can't, because the insurance policies are written in a way that says we will never pay until there's a claims bill. So there's every incentive to fight post-verdict, because there's a long lag time between verdict and claims bill. There's litigation going on during that time. This allows the local municipality to go to their insurance that they have already paid for and get it paid without a claims bill, without further litigation. This will reduce litigation on the bigger claims, the more serious claims. I know you've all heard the story of the officer on Daytona Beach who was drinking and ran somebody over on the beach. Cases like that, the really horrific cases, that woman is not going to have to wait 15 years to get paid because there's a claims bill process. Daytona Beach is going to be able to, if they want to, avail themselves of the insurance that they already have. This bill removes the requirement that the insurance won't pay until there's a claims bill. That's a very important streamlined process that reduces litigation. It is critical to this bill. So thank you, Rep. McFarland. These changes will enhance government accountability. We've all been in parts of Florida where there's just pothole after pothole after pothole. And there's a reason for that, because their worst day is $200,000. Now their worst day is $400,000, maybe those potholes.
That's a very important thing he just said. If their worst day was only going to cost them $200,000, and now it's going to cost them $400,000, maybe there'll be fewer lawsuits. Why? Because the state's going to go out and fill those potholes and prevent an accident from happening. That's a
Good
very
point.
important point he just made. And it's what we've been saying. It is the deterrent part of non-economic damages. It's the deterrent part of punitive damages, where if they see that it's going to cost them more, maybe they won't be as negligent in the future.
Well, it's also that it's a point in time fix, and they never have to deal with that issue again. Whereas the injured party, they have it for life, possibly.
Yeah, I mean, think about it this way. Travis, what if I told you that if you go out and speed, your speeding ticket is only going to cost you $10? And then I told you if you go out and speed, your speeding ticket is going to be $1,000. Of course, if it's $1,000, you're going to be very cautious about when you decide to break the speed limit. But at $10, you're going to go, nah, I need to get there today. It's worth $10 to me. I can pay that. But if you knew you were facing $1,000 for doing the same thing, you're going to go, no, I'll wake up a little early and I'll leave an hour early and I'll get to my destination and not have to speed.
You know, I will make a comment because the more I listen, the more I'm understanding. And you know, my concern is when some of these people keep saying this is a fair number. I mean, determine fair. Like how are they determining fair? And when you compare this to subsection 8 and what was tried, you know, this session, these same people who are okay with caps on these claims fought so hard against what would have repealed subsection 8 and yes, added caps to claims. So I have a hard time personally understanding where their real interest is. Is it the people or is it the price? Because if this bill that we're talking about here on this video has a cap that hasn't been adjusted in 13 years, and they're saying that going up a couple $100,000 is fair, then how can you say a law that's been in place for 34 years, repealing it and adding a cap is not fair? Like, how are they okay with this cap, but not, I don't understand that part. Does that make sense?
Is there a particular person you're talking about that's in this video that is being hypocritical? It sounds like what you're saying is somebody is being hypocritical.
Well, this gentleman, for instance, like he's thanking the sponsor for the bill, and I get it because it raises the caps. But in a perfect world, and the whole fight against Senate Bill 248 was the caps. So how are you okay with caps on this? Like, why don't we see that passion of no caps on these claims versus what we're seeing, like how we're seeing on Senate Bill 248?
Okay, I understand your question now because this attorney was at both hearings. He was at this meeting and he was at the one on the 22nd that dealt with subsection 8. And yeah, in that video, you're correct. He wanted to do away with the caps part of it. But in this one, he's saying it's good. Unless I ask him specifically, I don't know what his reason for that is. You do make a good point. The only thing that I could speculate is that because this deals with sovereign immunity and it's government that is involved versus a private individual as a doctor, maybe that's why he's accepting that caps should be on any lawsuit against the government. Because again, you've got that state interest versus the people's interest, but that's pure speculation. You know, we would have to ask him, and that would be a great question to ask him. You know, if you're against caps on subsection 8, why are you okay with caps on this? And he may not be okay with caps on this. He may just see that the fact that they're doubling the cap makes it better than it was. You know, he may not think that there should be caps on it, but we wouldn't know that without asking him.
Right.
Yeah, either
It's
way,
just hard
caps
to
are
hear
arbitrary.
those same people who spoke against caps. It's hard to hear them speak how they're calling these caps fair. I don't understand, I guess, that
Well, see,
part of it.
for one, he's working from a point of caps don't exist in one law statute, and then here they do exist. So he's trying to bump them up to better the people, whereas in 768 they don't exist. So he's trying to prevent them from appearing.
Right. And just like, you know, we hear the people who are not in agreement with this bill, we don't hear them talking about protecting those medical malpractice individuals, right? We hear them talking about their interests. Well, when Senate Bill 248 was up, people like this guy, we didn't hear him talking about how the bill would restore access to the courts for those people who fall into the subsection 8 category. We only heard them talking about the caps. So I think that argument actually, which I didn't think about that till just now, you know, it's a powerful point that when somebody is speaking, they speak on one subject, but they do leave out a very important other half of the issue. And that has been proven how it was done here and as well as in Senate Bill 248. I didn't hear many people, you know, as far as lobbyists talk about how repealing subsection 8 would be a great thing. You know, I feel like all I heard was how horrible caps would be, but no one really mentioned that except for the advocates that were there to give their testimony.
A good way to work through that argument, Sabrina, would be to ask yourself if you can come up with any scenario where caps would be appropriate. You know, for anything. It doesn't have to do with medical malpractice. It doesn't have to do with sovereign immunity. Is there any argument that you can think of where caps would be an important part of it? And if you can find even one, then start thinking that through and saying, okay, well, if I think caps are okay there, then why? You know, why are they okay there? And
right.
You know, one of the things that goes through my mind here is because they're talking about sovereign immunity. Keep in mind, these sovereign immune hospitals, or the hospitals who have sovereign immunity, they're hospitals that are funded by tax dollars. So I understand their argument that if tax dollars are going to be what has to make the payouts to people who are injured, we don't want those payouts to be excessive. I understand that, but I think they're going about it the wrong way. If you want to keep lawsuits from happening, then don't be negligent.
Yeah.
You know, it's like they're trying to pigeonhole you into arguing about caps when really the argument is about, well, just get rid of the negligence.
Yeah, I struggle with the whole caps argument. You guys know that because it was never part of my fight to begin with. And in all honesty, there's no jury that could award me enough and no cap that could compare to what happened to my dad. So with that being said, I feel like the legislator has been forced to pick a side. You know, either a jury is going to put a price on a person's pain and suffering, or a cap is going to put the price on a person's pain and suffering. And for me, neither of those will ever be enough because that was my dad. That is my dad. So it's priceless. But I have a hard time with the caps argument in the first place. I guess it's just strange to see somebody who was so passionate about fighting against the caps on one bill being so okay with it on another bill.
Yeah. I won't get into it now, but you know what my desire is to have a conversation with a few people about exactly what would be, I mean, since you want non-economic damages, exactly what would be that number that you would be okay with? You
Oh,
know,
I said I would do that. I would be in that.
yeah, I know you and Travis are the only ones who have been willing to have that discussion with me. I would love for other advocates to be willing to jump in and let's talk about it, because I think it would help put all of this stuff into perspective. Don't forget, the people who use the hospitals, who have sovereign immunity, are using them because these hospitals help indigent people. These hospitals help those who don't have private insurance. They're there to help the community. And so do you want, if you were to jury award them out of existence, if you didn't have caps on jury awards, then they would go away because they couldn't, they couldn't exist. And that's just a simple matter of math. So if they go away, does it harm the community more than the cap harms them? Are you following that train of thought?
I think so.
Okay. It's like in the private sector, you can sue a doctor for, let's say, $5 million, and his malpractice rates may go up, but he's probably going to still practice. But if you sue these hospitals that have sovereign immunity for too much and for too long, at some point the government's going to say, we can't afford to provide these hospitals anymore. So now the community is hurt because of that.
But see, why aren't they addressing the human entity that's causing that many issues?
You're preaching to the choir. I agree with you 100%. If there is a fireman, if there is a doctor, if there is a police officer, if there's a school bus driver, if there's anybody who is creating the biggest problems, get rid of them and the problem goes away. Because basically what they're asking people to do, the taxpayers, what they want you to accept, and I'm going to personalize it for you. Let's say that you hire somebody to drive you around so you don't have to drive yourself. And this person continues to get into wrecks, get into traffic accidents, to cause you damages that you have to pay. At some point, you're going to get rid of them, right? They don't want you, they're not addressing the issue of the bad actor. They're not addressing the issue of the police officer who abuses his authority, or the fireman who abuses his authority, or the bus driver, or the teacher, or the hospital. They're not addressing any of that. They just want you to accept that caps should remain extremely low.
Yeah. There should be a trade-off. It's like if you're going to force the caps, then you force them out of the job. I hate to take someone's livelihood away, but if they're repeatedly causing the issue that requires the cap, then if you're going to impose the cap, then impose the termination.
Yeah, and this goes back to the argument you made earlier last year about when we discovered that 4% of the doctors were causing 42% of the payouts, and we've actually now discovered that recent data has shown that it's 2% of the doctors who are causing 50% of the payouts. Would you not fire those two and recoup your 50% payout? Of course you would in a private business. But they've made it so difficult to fire people in government. In the private sector, it's a matter of dollars and cents.
And part of this, it is the people's fault for settling. If they're going to settle, they need to settle after there's a finding of fault, at least in the medical sense, because the 3 strikes rule does not come into play unless there's a finding. So if you're going to settle, make that a stipulation.
Yeah, and this is where they rely on people's emotions and people wearing down, the attrition, is what it comes down to. They'll drag it on until the person just has no more energy to fight, and they say, I give up. How much will you offer me to go away? And they offer them a very low settlement. The people take it and walk away. Where if they would stick to it, and I've had conversations with people who have lost a loved one to malpractice, and they'll say, I've been at this for this long and I just don't have the energy anymore, you know. And
I've
unfortunately,
always said if I could have pursued for what happened to my dad, that I would have never settled. I would have took it all the way.
yeah, you know, and it's just that's what the insurance companies rely on. You know, they want you to be so worn down that you're just unwilling to push it any further and just go away. You know, you've heard people say, I just want my life back. And then they just let it go. And the doctor is never held accountable. And in the case that we're watching now, the government is never held accountable. Well, let me start it back up.
Related to, I know the person who spoke right before me, he used a big number, and I haven't seen his numbers. I'd love to delve into that. But 107 million, I think he said. Sounds like a big number. But when you look at some of these hospitals, their revenues are 2.2, 2.8 billion every single year. Jackson, 2.2 billion. Okay. So 107, even if his numbers are right, 107 million sounds like a big number. These sovereign hospitals are doing just fine. Thank you very much. Thank you for your time and attention. And thank you for raising these caps. God bless.
That's all the public appearance cards I have. Members, we are in debate. Vice Chair Snyder, you're up first.
Thank you, Mr. Chairman, and thank you, Representative McFarland.
Travis, I know you sent me an email earlier where you had timestamped some things. So when we get to those points, tell me and I'll stop the video so you can share your thoughts on it.
Okay.
And for bringing this bill forward, I think as we had the conversation today, certainly some concerns came to light. I think that, you know, when we look at the CPI and just letting that just be baked into the cake is a slippery slope. And so I look forward to having that conversation. And if there's one thing I know about the bill sponsor, she is a good faith operator. And so we look forward to seeing hopefully some changes. I am going to support the bill today in hopes that we do see changes, because if we did get to the judiciary stop in the current form, I would not be able to. So again, look forward to those conversations, and we'll be up on the bill today.
Representative Beltran, you recognize in debate.
Thank you, Chairman, and thank you for everyone for a robust discussion this afternoon. Rep. McFarland, in her introduction, she spoke about the origin of the doctrine of sovereign immunity, and talked about the divine right of kings, and the king can do no wrong, and all of that mumbo jumbo that we don't believe in anymore because we fought a war. We fought a war about that a quarter of a millennium ago. We said we don't believe in the divine right of kings. We believe in a constitutional republic. And so what is the role of sovereign immunity in a constitutional republic? Well, the only possible justification for sovereign immunity in a constitutional republic is separation of powers. It's an argument. People have made all kinds of arguments today. They didn't make the best argument that they could have made, which is separation of powers. So I'm going to make it for you. I'm going to tell you why it's wrong. The argument would be that the courts and attorneys should not be appropriating taxpayer money in the form of a judgment against the state, because that's the province of the legislature. The Constitution commits spending to the legislature, and it's the people's elected representatives who are supposed to make spending decisions. That's what sovereign immunity is about in the United States. That's the only possible justification, but it doesn't hold up under the system that we have. Somebody mentioned claim bills. What's a claim bill? That's when the court's done its job. The case has either gone to settlement or it's gone to judgment. There's been a jury trial. There's been a summary judgment, whatever it is. There's a claim in excess, or a verdict, judgment in any event, in excess of the sovereign immunity cap. And somebody comes to this committee and they say, we want more money. And now we're sitting as an ad hoc appellate court over what that court did, the judgment that they entered, and we're essentially doing what's an implicit additor or a remittitor motion, where either saying we're going to go over the cap, how much are we going to go over the cap? Usually we compromise the claim bill. So we're saying, well, here is a judgment for X million dollars. We're going to pay you 0.6 of X because we're going to compromise it. And then we're going to do something about the attorney fees as well. That's what we're doing. How is that accomplishing separation of powers? That puts us, not all of us are lawyers. We haven't heard the case. We designate one of the judiciary staff as a special master to look at the details of the case. And then we give the claim bill 5 minutes. How is that? How is that being a good steward of taxpayer money, making sure people are compensated and in an appropriate manner? It's a broken system. And that's why myself and Rep. McFarland and other people have been working on this issue for such a long time. There was a suggestion from the audience that we should review this every 5 or 10 years. And that was in reference to the CPI issue. But the fact of the matter is it's been over a decade since we've raised the caps. The caps were inadequate back in 2010. They've been inadequate because there's been inflation the entire time. Rep. Juan Fernandez-Barquin brought this bill 4 years ago. I supported it. I ran it the last 2 sessions, and now Rep. McFarland's running it, and there's still opposition. So I don't know if we're going to get it done this year. In the last 4 years, since we've even been working on the issue, there's been double-digit inflation. So when you say don't do the CPI, let's wait and do this every 5 or 10 years, what basically you're saying is that we're always going to have caps that are inadequate. We're always going to be playing catch up. But when we do raise the caps, we don't even raise them enough. We end up with a compromise where it's not the full amount of the inflation. Now, we talk about the people said, you know, that the claims are going to go up. The amount of claims are going to go up. What you're really saying is that there are people now who are being injured who aren't getting compensated because it's uneconomical, or excuse me, impractical to make the claims, or it's not economical for the attorneys to take the claims. That you're saying that you're not compensating people now who deserve to be compensated, who if the caps go up a little bit, then maybe they can eke out a claim. That's really what you're saying. And the incidence of these damages, nobody chooses to be injured by the government. We provide fire, we provide police, we provide school buses. You happen to get hit, all the taxpayers of that county are paying taxes, all the school children, all of us are being protected by the police and the fire department. And then there's one guy, he happens to be crossing the street and he gets hit, and the entire burden that you've obviated by not having the right insurance or not being subject to the limits, it falls on one individual person. And then there's the argument about the leverage, that we're going to give too much leverage to the claimants. I'll tell you that when you bring a claim against the government, you have almost no leverage. The adjusters at the CFO's office, they're impossible to deal with. You could say they're very good stewards of taxpayer dollars. They have a lot of leverage because there are low limits. Most people don't know about claim bills. They don't think they can get them. The government's a repeat player. They have every incentive to grind you into the ground. I think they're tough. I think I'm tough, but I think they're tough. And it gives me pause to bring these claims. I'm still going to have pause to bring these claims. So I think this bill is a really good compromise. If I were in the industry or I were representing one of these local governments, I would want to take this bill. I would want to take these limits because these are very generous limits. Rep. McFarland set the level very low. It's a lot lower than what I've put in my bills. You all know that. And you said to me privately, we'd love to have you lowered it to these limits. We would be happy to accept the bill or not oppose the bill. And then here you have this great bill. I would lock this in, lock these rates in for the next 13 years. You'd be doing a very good job for your taxpayers. Thank you.
Travis, before you comment on any of that, I want to say people who watch our podcast should go back and listen to what Representative Beltran just said. Listen to it over and over and over again. He makes some of the greatest points in here. And he understands how our government is supposed to operate. And he's not putting up with any nonsense. Now, I'll shut up, and you probably had some comments on that.
Well, I like the fact that he recognizes that even if the caps do increase to 400, 600, you know, by the time they revisit this, that they will be woefully inappropriate for the cost of care 13 years from now. And that's what he's telling everybody. He's like, lock them in now while you can, because, you know, you're getting a bargain, you know, and that bargain is at the cost of the people. but he's trying to help the people out right now.
Yeah, something else when he was talking about separation of powers, I made a note to myself here. A couple of 3 weeks ago, I did a video. I think it was by myself. I did this one with Professor Randy Barnett talking about double deference. People should go back and watch that one because he explains about how the courts defer to the legislature. So the legislature is going to tell you that anything they do is constitutional because the courts will defer to them. And he calls that double deference. And Professor Barnett explains why that takes out the separation of powers that our Constitution had built into it. You know, and it's very important to understand that. The other thing that he talked about was these claims bills, and he explained it very well. If people will watch this again, you'll understand what they are. But there is something in the Constitution called bills of attainder, and if you'll listen to what he says about claims bills, and then search your Constitution for bills of attainder, they're forbidden in America. You can't have a bill of attainder. So he really brings up some great points. And when he talked about what you're saying when you say there's going to be more lawsuits is that what you're actually saying is people who have not been able to get an attorney to take the case because the recovery was so low, now they're going to. That's the same thing that Yarborough said in the committee meeting on the 22nd, that it's unjust that these people have not been able to get into court. They're making the exact same point.
Yep.
Yeah.
I agree. I like Rep. Beltran a lot. I think that he's very for the people. I think he's very knowledgeable on what he talks about. I know I've had a lot of good conversations with him. I'm honored to have him as part of House Bill 129, as he was, in the area where that happened to my dad, where I grew up. And I think he's very intelligent. I do think people should listen more to what he's saying, not just in this particular committee, but in general. He says a lot of very, he makes really good points, in my opinion. And sometimes I have trouble understanding what he's saying because his level of knowledge is so much higher than mine, which is expected, but I'm just being honest. So I really appreciate him. He was also one of the first people who spoke up and said, how can that hospital file claims on your dad's estate when they've been found at fault for medical malpractice? That's just wrong, and he publicly spoke out about that, referring to my father. So I really appreciate him, and I think he brings a great argument.
He really does.
Philip, you asked for the timestamp. It's in the next minute, the 34-minute mark, the 1
Okay.
hour 30 minute. So you're about to hear quite a few good points.
Okay, should I just let the guy who's about to speak, just let it through?
Just let it run.
Okay.
Yep.
Some Gottlieb, you're recognized in debate.
Thank you, Chair. If Rep. Beltran and I continue to agree, you may see the emergence of a new law firm. But I agree. I mean, first of all, the whole concept of sovereign immunity is classist. That's really, where it comes from, was that the king could do no wrong, and therefore you couldn't sue the king because he wasn't going to sit in judgment of himself. And as my colleague said, when this country was formed, we moved away from that system because we wanted say in our legislative process. But we wrestle here because we don't want our cities to go bankrupt, and I understand that. But I think 400, 600, it's low, but it's a step absolutely in the right direction. And I agree that there's many lawyers who won't take these cases at the threshold that they're at now. Yet we have people who are suffering grievous injuries. And so I do think that, maybe these municipalities, and I don't want them to get hurt, but when we're hearing about a small school district that has 40 pending lawsuits, maybe they ought to look at how they're operating. Because maybe the threshold is so low that we aren't deterring negligence. And I don't want anybody to get sued, but I think that when we look at the system that we have now, as Rep. Beltran said earlier today. If you suffer an unfortunate injury or death, you want it to be at the hands of a private actor, and because you can sue. It's really, it's strange. The same accident by a private actor and then by a sovereign immunity, you can only get $200,000 now. It's just, it's everything about it is wrong, because it might not be enough to compensate you to live your life the way you could have or should have. I think the numbers are low. I agree with the CPI. I hate to say it to the cities, because I'd like to be in lockstep with the cities. And that's, I talk about this often when we're up here. We wrestle with who we are supposed to serve. And it makes decisions like this very difficult, but I still don't think the numbers are where they should be. So for me, at this point in time, it's an easy decision to vote up on this bill, and I urge you to do so.
You want to comment there, Travis?
Well, he had mentioned the city with the 40 pending lawsuits. That's just a lot of lawsuits. Granted, I don't know the size of the city, how many people, but there's an area that needs to be fixed, and that is the prevention of those 40 injuries. Mentions because the threshold is too low that they're not deterring the negligence. We spoke about that earlier. A valid reason to raise it so that we can bring more rightful litigation to expose the faults, what's causing the fault. If you suffer an unfortunate injury or death, you want to be at the hands of the private actor. Well, those who are familiar with subsection 8, 768.21 subsection 8, that's not an entirely true story or a statement, because we can't effectively bring a suit because we're denied recovery, so we can't get an attorney. So he makes a good point in this respect, but he's apparently unaware of the other law, subsection 8.
No, he's very aware of it. He has spoke up on it.
He is. Well, I wish he had addressed it here just to segue into it. But
Well, I think the point you're trying to separate there, Travis, is somebody who dies from malpractice and somebody who survives malpractice. He's saying if you survive the malpractice, you survive the negligence, you would rather it be from a private actor because you can sue for more.
Correct. That's true. I see your point there. Yes. Yeah. Absolutely. You prefer to survive. You can bring your own cause of action. You don't have the limitations that subsection 8 imposes upon the estate. And he agrees that 200,000 is not enough because you cannot live your life the way you should have or could have. And that's the problem with caps under, subsection 8 is, well, if you survive, the caps could prevent you from living your life. Just like if you're injured here from a city employee, you may not be able to recoup enough to set up your house the way you need to, or get the durable medical equipment to live your life the way you could have or should have. He's really paralleling a lot of the arguments that we argue under 768.
Yeah, and I notice that nobody brings up the distinction between economic and non-economic damages here. So I'm guessing the caps on this are all of it, like economic and non-economic damages. I can't remember if it was this video or the other one that Sabrina sent, where they talked about compensatory versus punitive damages. But all they seem to be talking about here is compensatory. So it might be that those caps apply across the board if it's a compensatory damage.
Right. At the end, the bill sponsor, she speaks about the punitive and how you can't bring punitive against the state.
Yeah. Yeah. And it just leaves it where, I'll go back to what I said, it cannot be presumed that when the people created their government, that they expected to not be able to hold their government accountable if harm was done to them, So I love the point that he made about it's classist. That's exactly what it is. It's about an aristocracy that is above the people. And that's what we fought a war about. And he did bring up a point about it's not deterring the negligence. You know, it has to be high enough to deter negligence. So when anybody who works in government is negligent, they will stop and think twice. If I'm the guy in government that's going to suffer from this lawsuit, then I cannot allow myself to be negligent. And that could be a cop. I mean, I've heard stories about teachers who have done things that, you know, I won't get into all of it, but they've done things where a child's been injured due to their negligence, or sometimes just due to them committing a crime. And really, you want to put a $200,000 cap on that? You know, of course not. Anyway, I'll move on to the next one. Oh, last thing is I love what he said it when he closed about, you know, sometimes they forget who they're supposed to be serving. And in this case, it's not like in the subsection 8 argument where are you serving the corporate entities versus the people. Here it's, are you serving the government versus the people? All you have to do is look at Article 1, Section 1 of the Florida Constitution, and it says all political power is inherent in the people. That means the people are the sovereign.
Further debate? Seeing none, Representative McFarland, you're recognized to close in your bill.
Thank you, Mr. Chair, and I'm tremendously tempted to waive, but I won't give up the opportunity to talk. I have to give credit here to Representative Beltran. I care about this issue and I'm sponsoring the bill because he brought it to my attention. And this committee staff did when we did a workshop on it last session. And the reason why I'm sponsoring this bill, I'm not an attorney. I don't work in this area. I've never, a government has never committed negligence against me or a family member. It's not personal to me, but it is personal because I sat up here for an entire session. I heard claims bill after claims bill, and it broke my heart. And I understand now why it felt so strange to me. Representative Beltran explained why. I'm a legislator. I own the purse strings. I'm used to giving money or not giving money. And now, as I sat in this committee and I heard a terrible story after terrible story, and I looked at the amount of money that they were getting in settlement, and I thought that is not enough for a life that's been ruined, frankly. Another part of this bill that has my attention is that damages in cases of against the sovereign, they're compensatory. They're not punitive. The sovereign is not punished with an astronomical settlement amount or judgment amount. It's compensatory to restore that person, whether they've lost a life or a limb or property. And that feels right. I want my government to restore me if they commit a crime against me or they commit negligence against me. As I sat up here, claims bill after claims bill, or I hear a local government's argument about the cost going up, I know they will. I've worked in business. I'm usually a complete free market person. I'm usually very friendly to the Chamber of Commerce. I'm very friendly to my local government, but you can buy more insurance. And I know that will drive up my cost rate. And I represent Sarasota. Many of my local governments are self-insured. My hospital where my 3 children were born is self-insured. I know that this means costs will go up a little bit, but if one of my 3 children who was born at this public hospital it happens to get hit by a pickup truck that has a county emblem on the side of the door instead of just a personally owned vehicle, I have to wait years and years to come before the legislature with a claims bill and just hope and pray we happen to have a legislature who wants to hear a claims bill, because that wasn't the case for a number of years. That's hard for me. It's sad for me. I don't want that for myself. I don't want it for my citizens. That's why I'm bringing this bill. I write my own bills. I wrote this is a proposed committee substitute today because I wrote a couple things that didn't really make sense, and we've had to amend the bill. I put a CPI, automatic CPI adjuster in there because I didn't want to have to wait 13 years to come back and adjust the cost. I hope that it would flow with the market. Now I understand that often ideas that are very good on paper or on a PowerPoint don't play out in practice. This is an element I'm very willing to work on. I talked in response to a question from Representative Coster about working on a tolling provision. to allow the appropriate amount of time. Like, I want to make this a good bill, but I also want to make it easy for me to have restitution if something horrible were to happen to me at the hands of a local government. I think the win-win-win bills have all been taken. There are no easy solutions in this difficult job we do. I understand that. I know that I don't have all of your support, and I know I will not have unanimous support going forward with this bill. I support this bill. I'm asking you to support it. Thank you.
Then they take a vote. Only one person voted against it, so she got almost unanimous. Should I let the vote play? It passed.
I think she
Yeah.
did a great job at presenting this bill. I personally don't know her too well, but I think she did a great job. And you could really apply a lot of what she says to subsection 8.
Yeah, I think she did too. That was a wonderful video for you to find, Sabrina, and I can't thank you enough for sending it. I mean, earlier this morning, we had no intentions of doing a podcast, and when you sent that video and said you need to watch this, I thought, man, that's a perfect thing to talk about.
It was
I
intriguing because I didn't even know there was such a thing about, governments and caps and all that. I didn't know any of that.
I think one thing she might have wrong is I guess the definition of cost. She says, are the costs going up? But really, I would say they're no longer being subsidized by the people. Because that's really what it is the injury of the people are subsidizing, keeping the cost down. And that's really what's happening with subsection 8.
Yeah, another point that I wanted to make, and I kind of touched on it earlier, is you've heard me talk before about the interest of the state versus the interest of the people, what a senator does versus what a representative does. And you've got to think about the people who were used. Well, no, let me back that up. Why would the government have hospitals that they gave sovereign immunity to begin with? Well, that's because these are hospitals, whether they're a teaching hospital that's associated with a university, or an indigent hospital that covers people who don't have health insurance, and on various types of government assistance. They're looking out for the state's interest there. The state has taken over the responsibility of making sure that all the citizens have access to medical care. But in order to do that, they're going to have to give these people immunity from lawsuits. And that's where the whole idea of sovereign immunity comes from. The police and the fire departments are necessary in a civil society, but it's the nature of man that some people will abuse those authorities. And when that happens, you can't just ignore it. The people have to be protected because, again, it can't be presumed that the people they would vote for people who would take away their right to be compensated when government harms them.
So are the teaching hospitals, are they sovereign?
Some of them are. Some of them are. I mean, look at you have Florida State University, the university. Isn't there the University of Florida? I'm trying to remember.
Yeah,
I think it's UF.
I'm right up the road from UF, and I have been told by some local attorneys that they can't even sue for anyone's medical malpractice because I think there's a $250,000 cap. And I've always wondered, I haven't ever asked, but I've always wondered, why does Shands have a $250,000 cap, but other hospitals don't? I don't understand that. So is that what sovereign is?
They're accepting tax dollars. The hospital or the school associated with it are accepting tax dollars. Travis got into some of this with his civil rights case about the hospital accepting tax dollars.
There's the group that Mark Delegal is the general counsel for, Safety Net Hospital Alliance. The names on the webpage are Ascension, Broward Health, Halifax Health, Mount Sinai, John Hopkins, All Children's, Lee Health, Memorial Healthcare System, Jackson Health Systems, UF Health, Orlando Health, Sarasota Memorial, Tampa General Hospital, UF Health Jacksonville. The other one was University of South Florida.
What are those, sovereign, or those are?
University of Florida Health, I'm sorry. Yeah, these are all sovereign. And Nicholas Children's Hospital. Those all make up the Safety Net Hospital Alliance of Florida.
And that means that they're receiving tax dollars in some form. And the trade-off there is they receive the tax dollars, so they're going to have to, the government is going to require them to take care of certain people who can't afford to take care of themselves. And when they do, they give them sovereign immunity, you know. And that sovereign immunity, just like you'll read in the Magna Carta, it started out with you can't sue the king. That transferred in America to where you can't sue City Hall. And then it kind of trickled down from there to where police got, it's not called sovereign immunity with police, it's called qualified immunity. But basically it's the same thing. And now they're applying it to people who work in all areas of government, even the people who work at your local tag office where you go to get a license plate for your car. You know, they're covering everybody in government with this sovereign immunity or some level of sovereign immunity. But it all comes back to, you want to get those lawsuits to go away, don't be negligent. You know, don't abuse your power.
Well, it's carte blanche to do anything, really. You know, with police, it's carte blanche to violate your civil rights. In medicine, to violate statute, you know, notifications and such.
Yeah.
Just to be bad at medicine.
You know, and I could sit here and play videos for you all day long, all week long, for a solid month of video of cops abusing their authority because they know they can't be sued, you know. And this is what the struggle is all about. So,
Well, I think this was an eye-opening podcast, and I think that, you know, if you apply a lot of that to subsection 8, then it gives one more to think about.
yeah,
how the
you'll understand the arguments better. You know, I think you're 100% right, and I'm glad you picked up on that when you watched the video. And thank you for sending it. I think it's a great podcast. Whether people will sit here and watch the whole thing or not, I don't know or care. But I think it's great to have that information out there.
Yeah, I think it was a great piece of committee to watch.
Read the Magna Carta and the history of it.
Okay,
all editions of it. All editions of it.
Yeah.
How many is there?
Oh, I think there were like 5 different iterations of Magna Carta. It changed over, I think 1215 was the first one, and then it changed over the years. But then Magna Carta eventually evolved into something else and eventually something else. And but it ultimately led to the creation of our Constitution.
Yeah. I might just go to law school.
There you go. You could do that. You could certainly do that.
You know, I also kind of take offense that they want to reduce the discovery time to bring the suit from 4 years to 2 years to bring it in line with other torts. But I'm like, you're here to take care of the people. You know, you're for the people. Why limit our ability to fully vet the injury and then to bring an action? It's like you're purposely ducking your responsibility.
All right, but you know what I'm going to say. You know what I'm going to say. What am I going to say? It always goes back to the people. Until the people get involved in their government and make their and let it be known to their legislators, we don't want you taking 2 years away from us when it comes to discovery. Leave that alone. But you can't even get people to watch an hour-long podcast. So, you know, it's like Sabrina, we're talking the other day when we did our podcast. I guess it was earlier in the week. And I was making a point about these people that go to these meetings in Tallahassee and say, well, they only gave me a minute to speak. And I said, no, you got a year to speak. You've had all year long to make your point and to send your email.
Oh, it gets better. I had somebody text me and say, you didn't tell me the bill was up.
That's right. You told me about that. Like it's your responsibility.
I don't even have their name
Sabrina,
saved.
you didn't sign them up for automatic notifications?
I told them how to track the bill.
No, you have
And
to do it for them.
not happening.
Yeah.
Y'all would be surprised. People just expect to be told, everything. And then I'm wondering, even if I did tell you the bill was up, would you have went? I don't know. But I can't help everybody. I try. If they would watch podcasts, or you made a podcast actually when the bill was added. I think you made it by yourself. Didn't you?
On
So
this one, on this bill?
No, Senate when Senate Bill 248 was added.
Yeah, I did. Yeah. But I mean, welcome to America 2024. That, people just expect to be spoon fed. And that is not what our founders envisioned for our country. They expected people to be involved, and unfortunately, for at least the last 70 years, people have been trained how to not be involved, and we've allowed it to happen to ourselves.
And the problem is undoing the damage is very difficult, if not impossible, to do.
Yeah, and then somebody they'll hear this part of this conversation, and then they'll get all mad at me for saying that, and then they'll leave the group, or they unsubscribe or whatever, like they're going to teach me a lesson, and frankly, I've just gotten to the point, look, if you're, and I'll say it and I'll catch whatever heat comes from it. If your loved one was not important enough for you to get involved in this stuff, don't blame me that subsection 8 stays in place.
Well, what you just said is very realistic in the fact that most people don't get involved until it's happened to them. So each year that we have a bill on subsection 8, you guys see how many people show up to speak. This year we have a bill on subsection 8 and caps. That room was filled, not because of subsection 8, it was filled because of caps.
Yeah.
So once the caps topic goes away, the subsection 8 people are left standing. Those people were not there to support a repeal of subsection 8. They were there to make sure caps doesn't happen or express their views. So people only care usually when it happens to them, or if they can relate to it.
Well,
imagine if this was with auto insurance.
Yeah.
If you had a class of people who they're paying for auto insurance, getting services, and then their claim was denied because they fell into this class. Now you'd have a lot of people because, it directly affects them. And it's in their face the first moment. Granted, they hopefully wouldn't die in the auto accident, but it's just, you almost need to have more people affected in order to get more people to vocalize it, but you wouldn't wish that upon anybody at all.
Well, we got a whole year of new people coming, so just wait.
Well, to some extent, I can forgive people for not knowing about it until somebody dies, because I didn't know.
Me too. Me too.
We all just figure we can go to court if somebody's negligent.
Right.
So to that degree, I can forgive them. But once they find out about it, that's when I, would think that they would want to get involved. And even if their life situation is such that they can't get out and do the same things that you do, Sabrina or Travis or me, I mean, how hard is it to get on Facebook and invite all your friends and tell them about it? How hard is it to get your friends involved? At some point you can expand those numbers, but most people, and I see these stats through Facebook. Facebook shows me, if we put up a podcast, Facebook shows me how many people paused on the post long enough for Facebook's AI or Facebook's algorithm to recognize that somebody stopped for a minute to read. And then I can go to YouTube and see how many people actually watch the podcast. And it's pathetic, when you see how few people actually get involved, and it's speculation, but I'm guessing they just want somebody else to do the work for them. They're going to count on Sabrina to let them know when the next bill is up. They're going to count.
Will you please text everybody in Florida and let them know?
Yeah, they're going to count.
Most people have me blocked nowadays. I can't even text them. And I wouldn't even if I could.
They're going to count
Crazy.
on Travis to fight his civil rights lawsuit. They're going to count on me to write to, a senator with some research that I've done. But as far as getting involved on their own, you're just not going to find that many people.
Yeah. Did y'all see my email I had sent about the bill of attainder?
Yeah, I haven't had a chance to read it because we were starting the podcast, which I guess we ought to go ahead, unless y'all had anything else to add, we should go ahead and close this out. Was that something you wanted to point out in this?
Well, it's an incomplete thought right now. That's why I was bouncing it off you. So let's close this out, but stay on and talk about it.
Okay. Well, everybody, thank you for joining us today. Sabrina, thanks again. Great video. Anytime you come across something like that. I did watch the one you sent from the Senate, and I didn't think it was as good as this one. It's like they really...
No, but maybe we can do that one another day just because of some of the comments made by the senators.
Yeah. Okay. Well, like and subscribe, share us with your friends, get mad at me if you want. I don't care. I don't have that much longer on this ride anyway, so
I like your ending. They're getting better and better.
Am I?
Yeah. Do your own research if you don't believe me. That's one of them, right?
Yeah, there you go.
Look it up yourself.
Look it up yourself. Get involved. Yeah. Don't expect somebody else to spoon feed you. We'll be happy to point you to the mountain, but you got to dig for the gold yourself.
If you want to if you would like to track the bill that we just discussed, it does have another committee meeting where you, the people, can go speak. So go to myfloridahouse.gov. The bill number is what was it, Travis?
569.
569. You can hit that little yellow sun square, track the bill, sign up. It'll send you an email. I believe it's going to Judiciary Committee next. So for anyone who wants to speak on the bill that we just reviewed, don't rely on me to text you. Go to the website.
All right, guys. Thanks. We'll see y'all later.